Submitted, Mr. Chernoff?
It is.
Mr. Walgren?
Yes, Your Honor.
Thank you. The court takes into account the factors in Penal Code sections 1166 and 1272. Throughout this trial, Dr. Murray was presumed innocent, and certainly there is a constitutional guarantee of bail to pre-conviction status. Dr. Murray has been convicted of a felony by the jury. The jurors found beyond a reasonable doubt, unanimously, that Dr. Murray is in fact guilty of the crime of involuntary manslaughter. There is no statutory right to bail based upon this felony conviction. The court does evaluate the defense request for continued release on OR and bail pursuant to the provisions of the Penal Code sections to which I referred. The defendant shall be committed to the proper custody of the county to await judgment of the court upon the general verdict, unless, upon considering certain factors, the evidence supports a decision to allow Dr. Murray to remain out of custody on bond. The first factor is the protection of the public. Quite frankly, I feel that that is a significant and demonstrable factor in this case, and public protection, as far as I'm concerned, dictates that the defendant be remanded without bail, in view of the fact that Dr. Murray has been convicted of a crime involving homicide. This is not a crime involving mistake of judgment. This is not a crime involving administration of drugs per se. This is a crime where the end result was the death of a human being. That factor demonstrates rather dramatically that the public should be protected. Secondly, the seriousness of the offense charged and proven. The offense charged and proven in this case is a homicide, and the homicide is predicated upon criminal negligence in this case. As far as I'm concerned, that factor is a significant factor in terms of remand. Third, the previous criminal record of the defendant. As far as I know, that criminal record is non-existent, and that is a factor which would indicate to the court that Dr. Murray should remain on his posted bond. The fourth factor is the probability of the defendant failing to appear for the judgment of the court upon the verdict. Dr. Murray has made all of his court appearances. He has been represented by counsel. He has made appearances in the past. Quite frankly, I don't know if Dr. Murray would in fact make those appearances in the future, since he now is a convicted felon, and Dr. Murray has significant ties outside of the state of California. So I genuinely am not sure about this factor. The fifth factor is, once again, an overriding consideration, and that is public safety. Dr. Murray's reckless conduct in this case poses a demonstrable risk to the safety of the public. If Dr. Murray remains out of custody on bond, and even though Dr. Murray is a medical doctor, and even though he has been practicing, public safety demands that he be remanded. Based upon my evaluation of all of these factors, I conclude that remand is appropriate. Dr. Murray is remanded to the custody of the Los Angeles Sheriff with no bail, and in the interim, he is to be kept in the care and custody of the Sheriff and ordered to appear for further proceedings and formal probation and sentencing on 29 November 2011 at 8:30 a.m. in this department. I expect that the people will have specific restitution, we can wait a few moments, specific restitution-related issues in this case, pursuant to the provisions of Penal Code Section 1202.4, and be prepared to address any matters of restitution. Certainly, counsel are aware of the Realignment Act and the provisions of Penal Code Section 1170, Subdivision H. I do want sentencing memoranda filed by the people and by the defense in this case. Is there anything else to address at this juncture, Mr. Walgren?
No, thank you, Your Honor.
Mr. Chernoff?
No, Judge.
Thank you. For purposes of these proceedings, Dr. Murray's remanded, and the court is going to take a few moments to talk with the jurors, and members of the court staff will be talking to jurors as well. We are in recess. We are adjourned.
media contact, or they're still...
At all shocked by the decision in terms of the jury's verdict, but you were shocked that he is now in handcuffs.
I am shocked. I am shocked that the judge used this public safety reason, and then his failure. He said, he's always appeared, so there was no failures to appear, but he has strong ties elsewhere, which we talked about earlier, and he could have surrendered his passport, they could have been ordered to remain, maybe electronic monitoring, house arrest, but this judge took him into custody right now. It's unbelievable. By the way, that would explain that the defense probably knew about that, and that's why the sentencing is going to happen so quickly. And as I said to Glenn, and this is a very important part,